All right. Welcome, everybody. Hi, George. We're live. Let's give people a bit more time to join. Hello, everybody. So, let me start with noticing once again that we're sitting in silence if I'm not speaking. It can get quite awkward for people. So, I think there's a person distinctly responsible for this present in this call. So I would like to give the word to Ismael to allow him to protect himself or like defend himself for this after 9 or more weeks of lies and deceit.
Yeah, I'm wondering like who could be responsible for this? I mean, like people are looking at me every single week that we do this call, and everyone's blaming me for not playing some elevator music.
I'm
But
blaming you.
yeah, so once again, I'd like to apologize to every single community member for not having some perfect classical music to play for all of you today.
Bum 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 bum.
We're working on
Bum
these.
bum 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 bum.
Ahmed comes in to save the day, ladies and gentlemen. That's a first.
Thank you
Nobody's
so
ever
much.
done that for Ismail.
Wait, wasn't that my cue? I'm sorry, guys. That was a poorly timed elevator music.
No, your cue is a bit later, but elevator music is always welcome on this call. We have a dire lack of it anyway. All right, so I think that was enough of waiting for people to join. So let's get started with this week's community call, where I have with me my partner in crime and the resident disappointer, Ismail. Say hi to the people, please, Ismail.
Hello, everyone.
And I also have with me the much less disappointing team guest for the day, who is Ahmed Ghappour, the General Counsel of NIM. Say hi to the people.
Hi to the people. Hi, guys. I'll try my best not to disappoint at least as much as Smile.
It's a pleasure. It's a pleasure to have you, friend. So, as always, during the call, just please leave your questions and comments in the dedicated text channel, which we moved right above the voice channel that the call is happening on, so you can see it in the voice channel's channel group. And if you have any questions, suggestions, or comments or memes as the call is progressing, then please leave them over there. And we're going to be starting with a bit of a news roundup, as always. So this week, a big thing finally happened, which I've been promising for, I don't know, at least 2 weeks at this point, but finally we pulled it off. So NIM Connect is now available for Telegram as well. So the new release, if you download it, already supports Telegram. And hopefully a link is being shared to the blog post, which explains how you can set it up. So as a recap for those of you who haven't been with us before, NIM Connect is our one-click interface, which enables you to privacy enhance apps you are already using. So the next one on that list is Telegram. This is really big news for us because until now, we only had Keybase first and then the Electrum wallet. No, sorry, the other way. So first the Electrum wallet and then Keybase, which are pretty low usage apps. But Telegram, in comparison, is absolutely huge. So we are very excited about this because this is the first widespread to real world use case for the Mixnet. So thanks everyone for your patience, for waiting for this, and also thanks to all the shipyard grantees who are running the gateways and network requesters to make this possible at all. And also special thanks to all of you who are using NIM Connect because we are counting on our core community to provide feedback on it. So if you run into any issues or bugs as you're using NIM Connect, please make sure to report them in our bug reporting form, which will be shared on the dedicated text channel, so that we can make NIM Connect as awesome as possible, as fast as possible. An issue that we already heard about from our community is that right now in Asia, NIM Connect is working in pretty limited capacity, and that is due to the fact that right now there are not many networks and or gateways and network requesters set up in the region. So we are already working on fixing that together with our community. So please stay tuned. If you're in Asia, the quality of service will improve shortly. And now to Ismail's favorite disclaimer when it comes to NIM Connect, which he really likes to repeat to everybody all the time.
Exactly, and I'll keep on repeating it until it's not necessary anymore. So very, very important to note, you wonderful people, NIM Connect is in beta, so it's experimental software for now. Don't use it to topple your government yet. Well, in theory, you could try, but I don't recommend it for now. So please, please just keep using NIM Connect, keep showing it to other people who might be interested. Because the team is stress testing the mixnet, gathering real world data, fine tuning stuff. turning some knobs and optimizing things. So yeah, just don't forget NIM Connect is in beta.
Exactly. So that is one of the very important aspects of NIM Connect. It's the first like actual real world stress on our mixnet. So we're gathering a lot of data about that, and it helps us a lot. It's invaluable actually for us to fine tune different parameters of the mixnet. All right, so on to our next piece of news. We dropped a blog post recently, or during the previous week, about payments and privacy, because payments and privacy apparently don't mix. If you're interested in this topic, then make sure to read our blog post. It's a pretty good one. It is about something called embedded finance, which is a more and more powerful player of finance in general. So one of the interesting tidbits of the article is that the world is going really fast towards full cashlessness. So a lot of developed countries such as the UK doubled or even tripled the number of people who reported that in 2021 they haven't used cash or coins at all, and I'm definitely one of those people. Now, this is of course no doubt convenient for everybody, but has some really serious implications to financial privacy. So if you're interested in this topic, then make sure to read our latest blog post about this. Now I will hand over to Ismael, who has some interesting and exciting news to you guys.
Definitely. So let's have a short word about something called POAP, which is an acronym for Proof of Attendance Protocol. You might have heard about this before, you might have not. In any case, I'm going to explain it to you right now. So these last couple of weeks, or actually last week, we've hinted that we're going to try and see if we can reward people somehow, the people who are attending this community call every single week. We see a lot of famous faces, so to speak. I see some of you have been here since the first call and are still here today every single Friday, which I really want to thank you all for. So what we decided to do was create some sort of POAP NFT, which is a specific type of NFT that shows that you attended an event or experience. So I will be sending you a tutorial near the end of the call on how to claim your proof of attendance. And so please stick around until the end of the call to claim yours. And that's it.
Bum 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 bum.
So yeah, Sudo, are you having any technical difficulties? Because I'm about to send the mic over to you. Think you're muted right now.
Oh, damn. Indeed, I was muted. Sorry about that, guys.
You didn't know. Yeah, you didn't realize. It's all right.
Yeah, apologies for that. Yeah, so apologies for foreshadowing the POAP thing last week. You guys don't know how much actual effort went into to testing this and making sure it works. It's more complicated than it looks. So as a test run, please make sure to claim your POAP, and who knows, it may worth something more than just a POAP in the future, especially if you have more than one of them. But more on this at some later time. That's all I'm going to say for now. And now is going to be your cue very soon, Ahmed. Just wait for about 30 more seconds. So on to our next topic, because this week we're not going to feature a mixed node operator because apparently everybody's on holiday or something similar. So I'm moving on to our team guest. Now, a few months ago on our Telegram channel, someone asked our CEO, Harry Halpin, that the question was basically, how come the powers that be allow him to go ahead with a project like NIM? And first, Harry explained that strategically we're very close to the EU and based in Switzerland. And by the way, if you want to know why that's important, especially Switzerland, then make sure to listen to the recording of the previous community call with our COO, Alexis Russell, because we discussed this in detail. So after explaining that, Harry said the following, and I quote, "If anything happens to me or anyone else at NIM, we have a lawyer who the US government knows very well not to screw with." So today I have that lawyer he's referring to with me on the call. So now this is your cue, Ahmed. Say hi to the people, please.
Hi, everyone.
Welcome.
Hey, good to be here. Thanks for inviting me, Sudo and Ismael. It's good to talk to some members of the NIM community.
The core community, I
Oh,
would
sorry,
say.
it got cut out when I said I really look forward to the rest of the discussion.
So then, would you care to introduce yourself a little bit? What should we know
Yeah,
about
so
you?
my name is Ahmed Ghappour. I'm a lawyer. I've been a lawyer for over 10 years now. Before going into law, I was a computer engineer. I used to work at Silicon Graphics and Sun Microsystems on HPC, on their HPC lines. And I left engineering for law school. People ask me why, and I tell them one morning I woke up and took a stupid pill, and it made me really dumb. And then I decided to go to law school, and that's a joke for the engineers. But I do ask myself that oftentimes. But for better or worse, I went to law school and graduated. Shortly after graduating, I took a corporate gig as a patent attorney that lasted less than a year. Um, and somewhere down the line, I decided to jump ship and I joined a charity in the UK called Reprieve. At Reprieve, I represented Guantanamo prisoners and worked to resettle released detainees or clear detainees in various countries in Europe because they couldn't go back to their host countries or their countries of origin because they would be tortured, stuff like that. After doing the Gitmo work, the Guantanamo work, I moved to criminal defense work with a guy called Charlie Swift. Charlie Swift is the military lawyer that did the Hamdan case. It's a really big Supreme Court case. It is the reason that lawyers essentially are permitted to go see prisoners in Guantanamo. Of course, after winning that case, Charlie was booted from the military. And we met, funny enough, on a boat in Guantanamo, where I was telling someone how to hack an iPhone, and he overheard it and then ran across the boat and was like, "Oh my God, you have to come work for me." And I was like, "Who the hell are you?" And he was like, "I'm Charles Swift." And I was like, "Oh my God, I thought you'd be so much taller because you're a superhero." But yeah, so superheroes come in all shapes and sizes. At that point, I was in England. I moved to Seattle to work with Charlie, and we had a bunch of really cool national security cases, which means that essentially we did a lot of. I did a lot of cases that were where the defendants were accused of terrorism and material support of terrorism, where they were accused of espionage, and where they were accused of computer hacking and violation of the CFA. Over time, I left that firm and I started my sort of own thing. I realized pretty quickly that being a guy named Ahmed that represented terror suspects, I needed some institutional backing. In other words, I needed to be part of an institution to do the work, and so I started a project at the National Security Clinic in the University of Texas in Austin. So there, I got to work on hacking cases, espionage cases, and terrorism cases, and with students. And it was pretty awesome. I then moved to California, started another clinic at the University of California, Hastings. At some point down the line, while at Hastings, that's when we worked on the Silk Road case and Chelsea's case, her appeal, and a bunch of other interesting sort of matters at the intersection of liberty, security, and technology. And then shortly after that, I took another no, just kidding. I basically decided to go into doctrinal teaching, which means I don't I do research and write and basically teach from a podium now. Meanwhile, of course, I had met the NIM founders years and years and years ago, and they we became friends just because of there were some of the few people I knew that were had a pretty awesome moral compass and also in addition to their really wide grasp of technology, really got sort of geopolitics and wanted to at least learn more about the structures and authorities that enable mass surveillance. We met at I met Claudia and Harry over at CPGP in Brussels years and years and years ago, shortly after the Snowden disclosures about warrantless programmatic NSA surveillance at a global scale. And I think the rest is history. We just sort of stayed in touch, became very close friends. And more recently, I started to consult in the crypto sector. And one thing led to another, and I was doing a lot of work with NIM, and they asked me to join. And here I am. Keeping Harry out of prison. Just kidding. Just kidding.
That's also part of it, probably.
Yeah.
But just getting back a little bit to some of the cases that you listed as or the types of cases that you listed. For example, espionage. Is there any difference in as far as criminal charges go when you get charged with espionage versus I don't know, criminal misconduct or anything else? Is this a more serious sort of crime in the eyes of the law, especially in the U.S.?
Yeah, especially because to my knowledge, there is no statute that calls criminal misconduct a violation. So I'm not really sure. But most crimes are comprised of criminal conduct. Just there's like a law professor like head mind trick over there. I'm trying to do. I'm sorry, law professors are not fun. But putting on my GC hat. Yeah. So basically, the espionage laws are. Most federal laws, well, let's just start with this. In the United States, we have a state and federal penal system, right? Each state has its own criminal laws, and the federal government has its giant set of criminal laws, and they overlap sometimes and can. But generally, states have one unique distinction is that states generally have much lower sentencing. So states are responsible for most of the criminal legal enforcement in the United States, but they're generally less resourced than the federal government, and their mandatory sentencing is significantly less than federal sentencing guidelines. In the federal system, which is where you would find a charge of espionage, generally the same charge in the federal system that you might have in the state system will carry more time for having been convicted and having been found to have violated that crime. Which is to say, yes, espionage carries espionage and espionage-related crimes carry pretty deep sentences. The other thing is, just to orient folks, is that you can be charged with more than one statute, violating more than one statute, oftentimes for the same course of conduct, as long as the statutes are sufficiently different, right? And so you find that, for instance, in Chelsea's case, she was charged with espionage as well as violations of the CFA, the Computer Fraud Abuse Act equivalent, in military code. And that is because it was argued that the means by which the act of espionage took place was using a computer and accessing that computer without authorization, etc.
By the way, for those of you who don't know, when he says Chelsea, he means Chalsea Manning, our one and only Chalsea Manning, who joined Team NIM after spending how many years in prison?
Quite a few.
Quite a few years in prison.
Yeah. The first time or the second time?
Were there 2 times? I was not even aware.
Yeah, she was detained for some time because due to refusing on principle to respond to a subpoena request related to WikiLeaks.
More on that in a little bit, but for now, let's just jump back to 2013. So in May of 2013, Edward Snowden travels to Hong Kong, where he meets 4 journalists in a hotel. And a few months later, the Snowden revelations come to light, informing the public about PRISM and the NSA's metadata surveillance program, among many, many other things. Where were you at this time? Do you remember? And what were your initial thoughts? Did it impact you in any way?
Where was I when the Snowden like when it actually came out?
Yeah.
I was. I want to say it all depends because I travel quite frequently. So, like, right when the news came out, I think I was in. Right when the news came out, I was in London, but then when the first like CNN um, breaking news about the Verizon communications came out, I think that was the first sort of release. I was in New York City, so I was traveling between the two at the time. But it's definitely a game changer.
It was a game changer, and for those of you who don't know, so two main things led to the founding of NIM, as far as I know. One was the Snowden revelations, and the other was Zuboff's "The Age of Surveillance Capitalism," the book, which I recommend to everybody. Hopefully, someone can share a link in the chat to that book. So it was incredibly influential in more ways than this, of course. But if it wasn't for the Snowden revelations, then probably we wouldn't have NIM today. Is that accurate? Do you know, Ahmed?
Yeah, so I feel like that's very accurate for a number of reasons. So one reaction I would like to just to mention, one reaction I had at the time of the Snowden revelations was, oh, now people won't think I'm crazy. Because actually, having there were at least a few handfuls of people that were familiar with many of these programs just by virtue of having access to criminal defendants, right? So if you were working, I was working on a case, for instance, several cases where FISA had been used, right? And where using just very basic process of elimination, it was at least posited or hypothesized that the only way that this type of that a surveillance regime could have captured certain communications that led to, let's say, the investigation or led to a conviction, et cetera, that would have to be some sort of programmatic foreign intelligence gathering that did not just focus. What do I mean by programmatic intelligence gathering? I mean intelligence gathering and signals gathering, electronic data gathering that is not focused, for example, on individuals. It is instead focused on groups of people. It is not focused on a conversation that takes place at a time, place, or in a particular manner. It is focused on the content of the communication. So what does that mean? Instead of saying, I'm going to the corner of 4th Avenue and 54th Street, or Madison and 54th Street in New York City, and I'm going to stand there and I'm going to record X, Y, and Z, right? That's a specified time and place. Or I'm going up to this apartment and I'm going into that apartment to do X, Y, Z. What this does is the programmatic nature is to say, well, I'm just going to capture every conversation that happens to mention crypto, for instance. I'm just going to capture every communication from this person to all of their contacts. I'm going to go further and capture all the communications by a target's contacts and their contacts, and then their contacts is up to 3 hops away. And that means that for that one person, just capturing their communication could lead to the incidental capture of hundreds of thousands of conversations and so on, right? So at the time, I was like, one of the reactions was, wow, folks won't think I'm crazy. I'm not at all surprised. This is terrific, right? I mean, this is great that the news is out there. Why is it great that the news is out there? Because, at least in the cases that I had active at the time, I could file and challenge programmatic surveillance, right? This is something that we had a select few of us, and I would say probably led by Josh Draytell, who's a lawyer in New York City, who's pretty brilliant. We can hopefully I can talk about Josh and how great he is at some other point. But many lawyers at the time it was basically like shadowboxing. You would say, hey, judge, we think that this evidence was the product of an unconstitutional search or a search that violates the Foreign Intelligence Surveillance Act, and here is why. we then would insert a giant shotgun approach, right? Like almost like I'm going to mention every reason possible, right? Just in case one of these reasons exists, and hopefully the judge can then look at the secret evidence and tell us whether or not, it is true that the type of eavesdropping or surveillance that happened here was in violation of either the Constitution or of FISA itself, the Foreign Intelligence Surveillance Act. So this is a lot, obviously, to be laying on you guys, but just so far, we've basically been handed a black box, right? As a defense lawyer, the black box is the method by which certain communications were captured. We send the black box back to we send a list of arguments to the judges saying, hey guys, or hey judge, would you please peer into this black box and tell us if any of these methods of surveillance exist? Because if any of them exist or any of them happened to get this evidence, then we believe, or we would like to challenge the validity of that surveillance. The Snowden revelation, suddenly we could quote the New York Times and say, hey, judge, this is happening. You can't tell us not to look at it, and you can't tell us that even you're looking at it or permitting us to look at it would violate national security. I'm sorry, go ahead.
So basically what happened is that just like how we discovered many of the planets in our solar system, we saw their gravity taking effect on other planets, but we didn't see the planets themselves. So you saw from the things you ran into in different cases, the nature of the data that was presented as evidence, you saw that something is there that is illegal, right?
Yep,
or
absolutely.
unconstitutional. But then before the Snowden revelations, you had nothing to point at. You had to list all of these possible things that were happening in the background, and see what stuck, right?
Yeah, and this was like almost like a sort of, this was considered an innovation. The idea of presenting to the judge all the things that could have gone wrong and that were unconstitutional, and then having the judge basically decide whether or not those things happened. Almost 99.9, actually, I would say every time I've ever dealt with a motion like that, what the government would typically do is then say, well, sorry, judge, you can't rule on this because first of all, what they're asking for is to see the actual document, the actual FISA warrant application. And we're afraid that you can't show that to the defense attorney, even though they have top secret clearance. And the reason is that's national security, and that's it. And then you get the attorney general to sign off on that, or deputy attorney general. And basically what that does, to be frank, is it scares the judge into not handing over evidence to the defense. Because when you have someone who's at the position of the attorney general of the United States or the deputy attorney general of the United States, state that revealing certain documents to a defendant or to the defendant's counsel could seriously impact the security of our nation. You gotta understand, judges are like pretty old. They're by nature risk averse. So obviously they're going to rule with the government, and the defense will be deprived of an opportunity. So post Snowden, all of a sudden we could point to something and say, hey, this actually exists. And it's out there in the world, so you got to let us challenge it.
So then, as a result of this, and probably predicated on the Snowden revelations, you litigated the first criminal case to challenge the NSA's metadata collection. Now, I'm no legal expert. I have no idea about these things. So, what does that mean exactly? I mean, legally speaking.
Okay, so
with PRISM,
so the
harvesting.
The case was Moallen, and it was metadata collection. The case was a California, Southern District of California case, which is within the Ninth Circuit. And I believe the Ninth Circuit came out with its decision sometime in 2020, right? So, but this is a long time ago case. They were convicted back in 2013. Basically, the case is about 4 U.S. residents who were convicted eventually, ultimately, of conspiring to provide material support to an FTO, a foreign terrorist organization, and conspiring to launder money. What does that mean? It means 4 guys were convicted for sending about $10,000 to Somalia during the time of the drought because the money was alleged to have gone to a foreign terrorist organization called Al-Shabaab. That's a organization in Somalia, right? So on the issue in the case was, or the issue in the case as pertaining to the NSA surveillance, is that the argument was that the evidence used at trial was derived from an unlawful surveillance program that was run by the NSA. And it was unlawful at the time of the investigation, and that when we filed our motions to suppress the evidence, the judge should have in fact suppressed the evidence. The program, the thing that made it unlawful in this particular program was that it involved the bulk collection of phone records, including at least the phone records of one of the defendants, the lead defendant, whose name was Moalen, right? So the conviction happens in 2013. We go to trial. It was like a 3-week trial. After the conviction, that's when Snowden publicly discloses the existence of the data collection program, and including the bulk phone records program. That bulk phone records program is the first. It was the first revelation, and it was basically the fact that there was warrantless collection of the metadata on our telephone records, meaning the time and place and length of each call, and the recipient and destination, the source and destination number, etc. And the public disclosure ultimately informed the defendants in the case that information used to then support a Foreign Intelligence Surveillance Act wiretap order was collected illegally, right? So if you have evidence that's collected illegally, then you use that evidence to get a wiretap. That wiretap becomes illegal as the fruit of the poisonous or tainted sort of evidence, right? So what's interesting, the Ninth Circuit actually ruled for us, right? So the Ninth Circuit actually ruled that the now discontinued bulk phone records program, the Section 215 program, violated FISA. In other words, the program of bulk records collection violated the Foreign Intelligence Surveillance Act and likely also violated the Constitution. This was the court's ruling. Nonetheless, the court affirmed the conviction because they determined that the evidence was not that the evidence ultimately used against the defendants was not tainted by that initial bad search. That make sense?
Yeah, it does, definitely.
So that's why it was the first case to challenge the NSA bulk metadata collection program. It was the first criminal case to do so after the revelations.
So then, legally speaking, the problem was that the slight issue was that it's likely unconstitutional to do this, right? But then, what about not legally speaking? So I'm asking Ahmed, the citizen. You know, how do you feel about these practices? What drives you to fight against this?
So ultimately, I think that what drives me to fight against mass surveillance. So just to be clear, right?
Yeah.
So a couple of things. First of all, I don't think that this is anything that should cause anybody a surprise, right? So the fact that governments spy on their citizens and the citizens of other countries, to me, is just par for the course. I don't think of that as, oh my God, I can't believe. Perhaps I don't know. I'm just not as sort of idealistic about or I don't know what the term is other than naive about how power works, right? So the assumption is, at least coming from where I am, is that powerful entities will use any means to maintain power, and they see, surveillance as a non-violent means, right? In the same way that countries view espionage as a way to stop war, you might view surveillance, at least from that perspective, as a way to keep power, and you convince yourself that power is for the greater good, etc. Right? CEG, American exceptionalism, right, and arguments for. So that said, that's a given realpolitik, right? On the other hand, I do believe that that type of pervasive, persistent surveillance, and more generally, any usurpation of privacy directly impacts our ability to have freedom of expression, to have even freedom of thought. And with that to me is the sort of core of any sort of notion of people power that is even possible, right? You have to communicate in order to organize, and we have to be able to think in order to challenge any regime or any sort of structure, right? Or even to challenge ourselves. And the more that the more pervasive and persistent a surveillance gets, the less we can, the less sort of scope of freedom we have to think. And for me, that is the core and the genesis of almost everything, right? Which is why anti-censorship is so very important. And does that sort of make sense?
It does, definitely.
Yeah.
Definitely.
So,
Now,
for instance, you know, I'm go ahead. Sorry.
No, go ahead.
It makes me think about it. So I had a friend once that was locked up for 13 years or so. He was maybe he just turned 18. His friends did like stuck up a bodega in New York City, and he was locked up for some time. Gets out, and he's, you know, this 31 or 2-year-old man that's or maybe just turned 30, and he's now, you know, rejoining the world, right? And so I call him up one day, and he said the funniest thing. It's like, I've been standing in front of the fridge for like 40 minutes, and I didn't know why. I was just waiting for someone to tell me I could open it, right? And so to me, that is sort of a visualization of what, to me, in other words, like he was under that sort of microscope for 10 or 11
like
or 12 years.
Conditioned for that,
exactly.
For half of his life, basically.
Exactly, right. And it's the fear of, or the fear that you're being watched, right? Or the fear that someone will stop you, or it is that type of, that person or thing over your shoulder that I think is really dangerous for the functioning of free thought in society.
Yeah, that's a very good way of putting it. Actually. The expectation of being watched as you open your fridge.
Yeah, it's sort of like, I'll
stuff.
give you another example. One day I picked up a friend, this is also New York City back in the day. I picked up a friend who had just arrived from a third world country here, from not to be mentioned, right? But like, not to like associate it with any country, right? But I picked him up at the airport, and it's like 2 a.m, and we are in New York City, which is usually a really busy city, but at 2 a.m. on like a Saturday night on Canal Street or whatever, it's pretty empty, right? And so we're at a stoplight, and I'm there with this person and, you know, some other folks. All of us are from America except for this one person, right? And at the stoplight, my friend gets visibly agitated, right? It's like, what's going on? And I'm like, what are you talking about? He's like, you've been stopped at the corner for like 10 minutes. Like, I don't understand what's happening. And I was like, there's a red light. So it became two different sort of perspectives. Me presuming that I was being watched, right? And would get caught and issued a ticket and, you know, have all these repercussions if I was just to go straight and run the red light. And my friend, who's very practical about things, and he's like, well, listen, there's a red light, but there are no cars in the street. You should just go, right? So one is a very practical and efficient response, actually, is to just go. But one is, you know, I don't know if it's the same type of example, but it was just so, I think that the thing that I'm outlining is just how odd it felt to my friend to have me actually obey some rule, but the only reason I was obeying it is because of the fear of getting caught.
It's the conditioned response, once again. So these things are not always very obvious. They are very gray, and until you see them, you can't always put your finger on them. But these are both great examples to the importance of this underlying fact of me knowing that I have privacy in my life as I'm opening my fridge or whatever else I'm doing. That is incredibly important.
Exactly.
Now, moving on to a bit of a different topic, let's talk a bit about whistleblowing, because you have some experience defending whistleblowers. So so it takes incredible courage to do the right thing, when it involves directly going against some of the most powerful interests in the world, literally. Like, for example, Chalsea Manning did, or Edward Snowden did. But it is also at the same time very important because it is one of the important mechanisms to keep power in check, right? Because if it wasn't for Snowden, then we wouldn't know what the NSA was doing, other than lawyers seeing the gravity of something big but cannot point to it, and trying the shotgun approach. So in the Western world, presumably for this reason, there are some legal frameworks in place to protect whistleblowers. And what do you think? How well do they work in practice?
We definitely need reform on the existing set of protections that we have for whistleblowers and whistleblowing. And very broadly, the protections could provide more explicit, they could provide, for example, more detail as to the correct path to take within an organization before going to the public. That path should be set in a way that it does not subject the person with information, or the soon-to-be whistleblower, or the whistleblower, let's call him the whistleblower, that it does not adversely impact them, right? Anybody who's gone to HR and complained about a boss, right, probably knows the fear of going to HR, or should know, right? So, like, when I have a relative call me up and say, listen, I've been racially discriminated against, blah, 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 I'd like to go to the ombuds person or the HR in my corporation or company or entity or whatever, the first thing I do is ask them what the function, if they know any details as to what the function of that HR person is, what the function of the ombuds person is, because oftentimes their function is just to get you to drop the complaint, right? And to conduct surveillance on you in a strange way, right? So another time I've had a friend call me who's an administrator at a big school, and they were like, yeah, not my school, for the record, or any school I've worked for. So there's the disclaimer for the lawsuits. And they were like, yeah, I think that the role of these persons, these HR people and the ombuds person, is to basically conduct surveillance on the person that's making the complaint, to make sure they can diffuse it in some way without drawing any sort of legal implication or liability to the organization, the company, the corporation, etc. Right? And so we always have to balance whatever sort of path we are giving to a whistleblower. We have to make sure that that is extra secure, right? So that they, on the very, very first sort of level, don't have that fear walking into.
Because basically, whistleblowing against the NSA or the U.S. government is very much going to HR and reporting your boss on steroids. It's a much more severe and serious situation, and it's incredibly difficult.
Absolutely, because you're not just risking your job and your livelihood, you are risking potentially, being completely ostracized from that community, the intelligence community. You're risking losing your security clearance for reasons that you don't know, right? Because a lot of this stuff, when you have secrecy, any form of secrecy, people will use their imagination to fill in the blanks, right? So oftentimes you don't know why a certain decision is taken, even though you work for the organization, have all the clearances that are necessary, right? And that adds even more sort of tension. So that's one level, I think, in terms of what we can do in terms of legal reform. But I'm really the wrong person to ask about legal reform in the age of whistleblowing. I am almost, I don't know what to label my sentiments about this, or in general about. I would say almost anything that's led by a government initiative. or an initiative where the stakeholders have a power imbalance. So I'm not as hopeful that the United States, or any country for that matter, can, promulgate very clear whistleblowing laws that somehow, or protections that allow people to out their government agencies. It just doesn't seem like something that will happen to me. So instead,
Because they're fundamentally not incentivized to do so, right? They're fundamentally not incentivized to do so.
Yeah, they are fundamentally not incentivized to do so unless somehow, no, absolutely right. So what do we do instead? So I'm not hopeful, and that's why I'm at NIM, frankly, not just for the whistleblowers, but because I'm generally not hopeful in any sort of reform, whether it's a reform for privacy protection, whether it's a reform for anti-censorship. I definitely do believe in technology and math a lot more. And I think that with the right tech and math, we should be able to take those very, very, very basic powers back, and do so in a way that, somehow, right, allows society to flourish.
Yeah, because tech, just as much as law in general, is also, it also structures our reality. It's so you can make it a fact of reality by law that whistleblowers have adequate protection against those who they are blowing the whistle on. But if you have the tech to enable that, in an unyielding way, then the change to reality is the exact same thing, or maybe even better. And NIM is doing that, I would say.
I agree. I think that that's a huge component to it. Many would argue that one of the problems in sort of social structures like governments, as opposed to technical structures, is even when rules are set, they have different interpretations. Of course, non-rule based tech, in other words, like more the AI sort of focused technology might also have some of that fuzziness. But yeah, it's really hard to trust a contract or to trust words, I guess, is what I'm saying.
Exactly. I agree with that. It's a bit of a pivot, but I wanted to talk to you about something that comes up a lot, especially in the Web3 privacy space, and also we like to refer to it at NIM. Privacy is a human right, and that is not just something we like to repeat. It is also in the Universal Declaration of Human Rights of the UN. A link was, by the way, posted to it in the community call text channel. So that seems like a pretty powerful thing, right? Our privacy is protected as a human right. Yet PRISM was somehow legal, and Google's and Facebook's surveillance practices are somehow legal, and surveillance is basically ubiquitous today, entirely ubiquitous. How is that possible? And what can we do against that?
So how to answer this question? Why is NSA surveillance abroad legal, despite the fact that privacy is a human right? Right, and well, if you asked, there's many would argue, right? Many would argue that the geographic scope of any convention, any relevant convention that the United States is a signatory to, that relevant scope is the territory of the United States. In other words, we are obliged to honor the human rights under that convention. We are obliged to honor the human rights of folks territorially, but to non-U.S. citizens abroad, it does not apply. We have the same position, by the way. The United States has the same position on the Constitution. So let's look at the Constitution. Constitution of the United States, let's say, has a right of privacy, right? And that's under debate. It's not explicitly in the Constitution, but there is a Fourth Amendment that prevents or protects the people against unreasonable searches of their places, possessions, and so on, right? Person. And even then, let's say we read in a fundamental right to privacy in the Constitution, even then, the Supreme Court has been very clear that the Fourth Amendment does not apply to non-U.S. citizens overseas.
So that's why. And what about the private aspect of this? So what about Google collecting, all the data?
Yeah, so generally, public international law. Well, not I won't make a blanket statement about public international law, but generally, the Constitution of the United States does not apply to only applies to the government, restricts the government from action, right? So you have a First Amendment right here in the United States, and for example, and that protects you from the government usurping your speech, right? But it does not protect you from private actors telling you to shut the fuck up. Sorry, I used the F word. I'm also
It's okay.
a lawyer, but
we're all adults
okay.
here. I hope no kids are listening to this. If
Good.
so,
Raise your
then
hand if you're
apologies.
offended.
Don't do drugs.
Trigger warning.
Don't do
Okay,
drugs.
so
Stay in school.
yeah, but I guess my point is that in many would argue that certain things, like certain, especially internationally, right? Especially agreements between states internationally, or what we would call international law, customary international law, etc. Many would argue that these sort of guidelines are there, true, but it's really the politics that underlie them that actually control, which is why it's different when the United States invades a country from when, I don't know, Iraq does. It's just, in addition to any justification, right? It's just the most powerful country in the world doing something, and a not so powerful country in the world, for example, doing something, right? Who do you think will get out of it easier? It's sort of like we are the Duke lacrosse player of countries, right? So we could do whatever we want, and we'll still. Did non-Americans get that reference? Do you guys know about the Duke lacrosse player reference?
I didn't get that, and I'm not American, so
Me
I think we don't.
Yeah, it's
Non-Americans
basically
replied.
we have this thing here where like there were a bunch of Duke lacrosse players that were charged with sexual assault, but because of the racial dynamics and the power between, I guess, first the racial dynamics. At least this was the commentary, and also the fact that lacrosse is a kind of a privileged sport, I think, at least here in the States. And so all of these lacrosse players are pretty rich. And their parents got into it, and basically they were all cleared entirely of everything, right? And so for me, it's like the United States with other countries that are significantly as powerful, but really the U.S. can do a lot without really getting with some level of impunity, right?
Mm-hmm.
Bad reference for non-Americans. My bad.
It's fine.
Is there an equivalent in Europe, like of the Duke lacrosse player?
I'll be completely honest with you. I don't know what lacrosse is. That's how European I am. So your reference completely failed on me. Apologies for that.
Yeah. It's sort of like hockey with a ball, but not really. Does anyone in the audience know? Never mind. I'm not sure they can. We'll do it during the Q&A. Yeah, so I guess the question is like, why in light despite the fact that we have international human rights law and other laws, do countries do whatever? Because at the end of the day, I mean, this is sort of something I think I learned as a parent, right? Like you will only deterrence only works to the extent that the person you're trying to deter believes they will get caught. Kind of goes back to our first thing on freedom of thought, right? But like, the United States either doesn't believe they'll get caught or doesn't care, right? So that's why stuff like NSA surveillance happens in light of laws that clearly work against it, right? So
cautious of time. that we have two options here. I have one more question that I prepared for you, or if you really have to go at 0:00, then I have two questions from the community. Which one should we go with?
I do have to go at 0:00, so let's just do just because I have another really important meeting. So let's just why don't we just fire off all the questions? I could sort of handle it.
All right. So from our amazing dude who left his name is Dude actually. I'm not just giving him this name. He left the call in the meantime, but I think he asked some good questions. So the first is, the USA has some control over the data and information flows that pass through the submarine cables. Do you think NIM can be adopted in the USA?
Do I think NIM can be adopted in the United States? So basically, let's never mind the United States for a second. Is the question from a technical perspective, given a country with a very sophisticated government, very quote unquote cyber sophisticated government, in other words, they have all the tech and resources, could someone within a territory that has sophisticated traffic monitoring use NIM, and what impact would it have on both the functionality of the NIM network and the ability of the functionality of the NIM network, right?
Yeah.
I think I think that this is exactly the type of threat model that NIM ought to be able to work under. Like but I do defer to our tech people. So my understanding is if there's a choke point, undersea cable, right? Let's say you get all the communications in that choke point. What's the next step?
I think it is just as relevant. This question is just as relevant to China with the Great Firewall of China. So I think one of the key things that NIM has to do. Also, I'm not technical enough to answer this question in its full capacity, but you know, for NIM to achieve its full goal is to work under those circumstances. So as to enable adoption in those regions, and I know for a fact that we're working on doing that, on achieving that. But I think maybe the next question is more is better for you specifically. This is also from Dude. Do you think that the USA could adopt measures which would prevent the countries of the South from adopting NIM? And this, I guess, ties into the whole tornado cash situation with the OFAC sanctions, which is not, of course, not limited to the US. Its impact is not limited to the US, but it is very much a global. It has a global impact.
Okay, so if I'm understanding this question right, and the previous question, I think they are related. You're right. So the first question sounds like, will NIM be, or can NIM work if a country is trying to block communication or filter out all the entry node equivalents or gateways, right? That's the idea.
Yeah.
Okay.
Yep, that's
then
how
the second question
well.
is whether the United States could take a measure like that to make other countries do that. So I actually, let's stick on the second question. I think the first question is a technical question, and it is definitely something that we are, to my understanding, working to enable. And the second question relates more to whether the United States can make other countries work that way. So, or whether the United States can somehow implement some filtering that forbids other countries or citizens and or individuals, people in other countries from accessing the NIM network, right? So that would be the equivalent of basically the United States telling a country, let's say country X, to filter traffic, right? To target or to outright ban.
Criminalize the use of it. Yeah, just like it basically happened with Tornado Cash, right? That's a very
no. Wait, time out. So Tornado Cash is different. So there are. So the United States, that's different, right? So with the question, my understanding of the question is, can the United States make another country forbid its citizens from using NIM? Right. So that to me is a foreign relations question. Can the United States make another country do something, the word make is sort of a hard word, right? But can the United States influence another country into doing something? Yeah, that's called diplomacy. It could be hard diplomacy or soft diplomacy. Soft diplomacy could be like, hey guys, shouldn't you really do this because it's the right thing to do? But hard diplomacy is actually trying to get a deal, some sort of agreement between the two countries that is conditioned upon certain sort of measures the country would take to prevent folks from getting onto NIM. Now, let me just sort of like back up a tiny bit. And because you did mention Tornado Cash and OPAC, just to back up a tiny bit, I think that it's worthy to sort of worth understanding the difference here. OFAC here in targeting and designating Tornado Cash, is explicitly targeting a virtual currency mixer. Cool. The NIM network is a VPN. It's not a VPN, obviously, but it's a privacy network, right? So what's the difference between a mixer and a network, and why does this come into play when the United States is designating entities, right? And so on the one hand, the only countries that I'm aware of, just for the record, that actually outright ban or prohibit the use of a privacy-enhanced network is Belarus, Iraq, North Korea, and Turkmenistan. Those are the only countries that I'm aware of that actually ban the use of a privacy-enhanced network. So for the United States to make another country ban VPN, it would be the equivalent of making them ban VPN. Now, why is NIM the equivalent of VPN and not a mixer? Let me explain that really quick, because that's very important. So a mixer, I'm going to try my best here, right? A mixer is a layer 2 service, typically, and it accepts and transmits currency, virtual currency, in a manner that is designed to prevent any manner of tracing or transmission of funds back to the source. Oftentimes, this involves actual taking custody of the money, of the currency, pooling funds from multiple sources into various wallets that are often owned by the service or in the custody of the service, and so on, right? And then releasing them in fragments to the destination wallets at the random intervals, etc. We know how that works. Now, what's the difference between that and what a VPN is, what a network is? A VPN, or the NIM network, let's just be clear. A privacy-enhanced network, or the NIM network, is a computer network. What is a computer network? A computer network is a layer 0, not a layer 2, layer 0 service that will accept and transmit that allows computers to exchange data, right, and share resources with each other using a communications protocol. On one hand, you have a service, layer 2 service, right, whose idea is to prevent tracing, right, by taking some custody of the actual currency, etc. And the other one, layer 0 service, allows interconnected computing devices to exchange data, very broad data, using some communications protocol. What are some examples of a layer 0 service that allows interconnected computing devices to exchange data? You guessed it, HTTP, right? And can layer 0 services that allow interconnected computing devices to exchange data and share resources have varying degrees of privacy? Absolutely. Can they have varying degrees of security? Absolutely. What's an example? HTTPS. There's an example of a computer network that is more secure and private than HTTP, right? So what makes a network and not something else? Like, why is it that we care, right? So a privacy network is no different. A privacy network is no different than a non-privacy enhanced network or a non-anonymity enhanced network, in that it maintains the end-to-end principle of network communications. What does that mean? That means what goes in comes out. What goes in comes out. It's not held. It's not processed. It's not tumbled. It's not anything. What goes in comes out the other end. And that principle, that end-to-end principle of network communications, is the fundamental principle that allows us, quote unquote, big US, allows the regulators to focus their regulation on the endpoints. Because so long as the tech processes as a conduit, merely that, what goes in comes out, then you can regulate the endpoints. And that's the sort of theoretical underpinning under which that governments generally won't touch a network, right? Because if you are going to start to regulate a network, you're going to regulate the telephone, frankly. You're going to go after HTTPS, and you're going to regulate, literally, we will turn into fucking Turkmenistan, where I've never been. Okay, so just one thing. What does a privacy network do in addition to maintaining that end-to-end principle? The one thing it does that's additional is that it obscures the fingerprints, the digital fingerprints, the metadata that is left behind when we engage with the internet. It's that simple, right? So what are some examples of privacy networks that are in existence, predate NIM? Now I'm talking about privacy networks, not just ordinary computer networks. Privacy networks are a subset. I would say Tor network is one, and I would say NordVPN. Anyone use NordVPN? I don't work for them, so I'm not pimping them out. I use them.
I was waiting for a sponsor spot, but then I'll be disappointed, unfortunately.
Bum. I do. So what I'm saying is, we can get into this in great detail, and actually, I would like to just announce to our very small exclusive set of listeners here that this week, hopefully, Sudo and I have been trying to get a Twitter space together. We will on specifically the tornado cache issues, and now I think the issue is like ripe enough for us to talk about in great detail, and we'll probably do that this week. And we will probably do that with a surprise guest. And the surprise guest may or may not be Josh Draytell, who's a brilliant lawyer. And frankly, one of the best people that work in this area. And it should be really fun.
Okay, so I was going to do some...
I'm 7 minutes late. I'm so sorry.
All right. Many thanks for joining, Ahmed.
No, do it. It's okay.
So actually, I was about to foreshadow, in some ominous way, so that people are left guessing. But now you ruined the whole thing, including our special guest. So many thanks for that, ladies and gentlemen. Next week we're gonna have an awesome Twitter Spaces for you to dive really deeply into the legal aspect of and ramifications and implications of Tornado Cache with Ahmed and Josh. If you want, we can let you go, Ahmed.
Awesome. Thanks, guys. I really appreciate the audience. And I could talk forever, as you know, right? So just hit me up. Talk to you later.
Thank you, Ahmed. See you later. Bye. Now, for the rest of you guys, the call is not over yet because we promised you the whole PO-up thing. So I'm going to hand over to Ismael, who's going to explain to you what you need to do. But first, I'm going to just, because I'm going to stop the recording after this, so I'm going to give you the usual outro. So the call, as usual, has been recorded. I'm going to share it on our YouTube channel on the usual playlist throughout the weekend, probably. So if you missed any part of it, I saw you, Sergo. You just joined for the end of it. Don't worry, it was recorded, so you can listen to the whole thing. It was incredibly interesting. And as always, if you have any suggestions for topics or guests or whatever in between, then make sure to let me know, whether in private or in our public channels. Either is fine. And now I'm handing over to Ismael.